Welcome to the United States Constitution, a presentation of the Cato University, a project of the Cato Institute. The United States Constitution was written by George H. Smith and narrated by Walter Cronkite. The quotations are read by Pat Childs, E.R. Davies, Craig Deichmann, Michael Edwards, David Ford, Travis Hardison, Don Jones, John Lutz, Sam Mercurio, Michael Montgomery, Hugh Sinclair, Sam Chuchivas, and Robert Wynne. This recording of the United States Constitution was produced in 1987 by Carmichael and Carmichael Incorporated, which holds the copyright thereto. Neither this recording nor any portion of it may be reproduced or used for any purpose without prior written authorization from Carmichael and Carmichael Incorporated.
In the summer of 1787, 55 delegates from 12 states gathered in Philadelphia for the Federal Convention. The purpose of this meeting was to create a central government with powers greater than those authorized by the Articles of Confederation. Ratified in 1781, the Articles of Confederation had been severely criticized, especially by James Madison, Alexander Hamilton, and other proponents of strong central government. These nationalists spearheaded a movement for a convention that would strengthen the central government. By 1787, most American leaders believed the Confederation Congress, the central government created by the Articles of Confederation, was too weak to solve the economic and political problems besetting post-war America. This was the task assigned to the Federal Convention, to strengthen the federal government. Delegates were instructed to correct, amend, and enlarge the Articles of Confederation. But a funny thing happened on the way to the convention. Delegates from Virginia held pre-convention meetings in Philadelphia's Indian Queen Tavern. From these meetings, and from the mind of James Madison, there emerged a rough outline for a new constitution, known as the Virginia Plan. On May 29th, as the convention got down to serious business, the Virginia Plan started things off with a bang. In a federal convention authorized by a federal Congress, the Virginia Plan opened with an assault on federal government. This political bombshell was the work of James Madison, but Edmund Randolph, governor of Virginia, delivered it to the convention.
Resolved, that a union of the states merely federal will not accomplish the objects proposed by the Articles of Confederation, namely, common defense, security of liberty, and general welfare.
The second resolution of the Virginia Plan criticized state sovereignty, the legal foundation of federalism. The third resolution offered an alternative to federal government. Randolph, echoing Madison, called for a national government.
Resolved, that a national government ought to be established, consisting of a supreme legislative, executive, and judiciary.
In 15 resolutions, the Virginia Plan sketched its vision of a national government. Some of its proposals, including two considered essential by Madison, never made it into the final Constitution. They were bargained away, the inevitable casualties of political compromise. Nevertheless, the impact of the Virginia Plan on the final Constitution was tremendous. Its call to institute a national government led to a new Constitution, rather than to a revision of the Articles of Confederation. Madison and other nationalists argued for a national form of government. Yet other delegates, especially those from small states, argued for a federal form of government. This was the most fundamental controversy of the Philadelphia Convention, as the nationalist Edmund Randolph put it on June 16th.
The true question is whether we shall adhere to the federal plan or introduce the national plan. The insufficiency of the federal has been fully displayed by the trial already made. We must resort to a national legislation over individuals.
What did delegates mean by the terms federal and national? Well, the word federal described a central government created by a voluntary union of sovereign and independent states. When delegates referred to this kind of union, they used the noun confederation. When they referred to the central government authorized by a confederation, they used the adjective federal. The word national described a central government created by a voluntary union of persons or as Madison put it, by the supreme authority of the people themselves. This carried important implications. The national government, authorized by the supreme authority of the people, would become the supreme government of the land. A national government would be sovereign over states and their citizens. As the nationalist Gouverneur Morris said, "In all nations there must be one supreme power and one only." Does the Constitution establish a federal government or a national government? This question has provoked bitter and bloody conflicts in American history. A nationalist interpretation eventually triumphed during the 1860s, not by force of argument, but by force of arms. 600,000 Americans lost their lives in a conflagration grounded in clashing views of the Constitution. Some Americans call this the Civil War. Other Americans prefer to call it the war between the states, and so the national federal dispute lives on in the language of American history. How did Americans of the 1780s view the matter? Well, they couldn't agree either. Some Americans opposed the Constitution because they believed it established a national government. James Madison mentioned this objection in the Federalist Papers.
The convention, say the adversaries of the proposed Constitution, ought to have preserved the federal form, which regards the Union as a confederacy of sovereign states, instead of which they have framed a national government, which regards the Union as a consolidation of the states. And it is asked by what authority this bold and radical innovation was undertaken.
Madison, in a famous reply, declared the Constitution to be neither wholly national nor wholly federal.
The proposed Constitution, even when tested by the rules laid down by its antagonists, is in strictness neither a national nor a federal constitution, but a composition of both.
Madison was right, of course. The Constitution is often described as a bundle of compromises, and some of these compromises softened the nationalism of the original Virginia plan. But to say the Constitution is partly national and partly federal is not to say these parts are equally important. In its fundamental structure, the Constitution is primarily national. To illustrate this, let's compare some features of the Constitution to the document it replaced, the Articles of Confederation. The Articles of Confederation, ratified in 1781, began with this line:
The Articles of Confederation and Perpetual Union between the States of New Hampshire, Massachusetts Bay, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, Georgia.
The Articles of Confederation were an agreement, a social compact between sovereign and independent states. Compare this now to the preamble of the Constitution of the United States.
We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America.
The Constitution's preamble opens with "We the people" and never mentions the states individually. This was no accident or oversight. On August 6th, before the final preamble was written, a preliminary version had been submitted to the Philadelphia Convention. Drafted by a committee of detail, this early preamble mentions both the people and the states.
We, the people of the states of New Hampshire, Massachusetts, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia, do ordain, declare, and establish the following Constitution for the government of the United States.
As the convention approached its final week, a 5-man committee of style was instructed to write a polished draft of the Constitution. This committee's preamble, the one we know today, was the work of Pennsylvania's Gouverneur Morris, an ardent and intelligent nationalist. Morris was not exactly friendly to state governments, as he made clear during one debate.
State attachments and state importance have been the bane of this country. We cannot annihilate, but we may perhaps take the teeth out of the serpents.
Morris, in excluding a listing of the states from the preamble, delivered a serious blow to state sovereignty. Under the Articles of Confederation, the states retained their sovereignty. The central government created by this agreement, the Confederation Congress, had only those powers expressly delegated to it by the states.
Article 2. Each state retains its sovereignty, freedom and independence, and every power, jurisdiction, and right which is not by this Confederation expressly delegated to the United States in Congress assembled.
To understand the reasoning behind state sovereignty, we must realize that, before the Philadelphia Convention in 1787, all but 2 states already had drafted and ratified their own constitutions. Indeed, some of these constitutions, especially those of Massachusetts and New York, were used as models for some parts of the United States Constitution. State constitutions established individual states as sovereign, independent entities. This was the legal foundation of state sovereignty, and state sovereignty, in turn, was the legal foundation of the Articles of Confederation. The Constitution never refers to the sovereignty of states. On the contrary, it declares itself the supreme law of the land, a law superior to the laws of individual states.
Article 6. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding.
Notice how the Constitution, in this famous Supremacy Clause, declares itself supreme over state laws and over state constitutions. This is a radical departure from the Articles of Confederation. Indeed, this difference is implied in the very word Constitution. For 18th century Americans, a constitution referred to the fundamental law of the land. Some historians call the Articles of Confederation America's first constitution, but by 18th century standards this is a misnomer. The Articles never claimed to be a constitution with the authority of fundamental sovereign law. Rather, as stated in Article 3, the Articles were a league of friendship entered into by sovereign states, and the constitutions of these states were their fundamental laws. The Constitution of the United States, on the other hand, conveys sovereignty in its title. The word Constitution asserts implicitly what the Supremacy Clause asserts explicitly. This point is reinforced by the clause which immediately follows the Supremacy Clause. In Article 6, all state officers, legislative, executive, and judicial, are required to swear allegiance to the United States Constitution.
The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States.
The Constitution delivers another blow to state sovereignty in Article 4, Section 4.
The United States shall guarantee to every state in this Union a republican form of government, and shall protect each of them against invasion, and on application of the legislature, or of the executive when the legislature cannot be convened, against domestic violence.
As a guardian of republican governments in every state, the Constitution empowers the national government to assess the fitness of state constitutions. The Constitution further undermines state sovereignty in Article 1, Section 10. Here states are expressly prohibited from engaging in certain activities, and many of these activities in 18th century eyes were powers essential to a sovereign government.
Article 1, Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in a war unless actually invaded or in such imminent danger as will not admit of delay.
The national character of the Constitution also is illustrated in how it was ratified. Again, let's contrast the Constitution with the Articles of Confederation. Here is the method of ratification specified by the Articles.
Article 13. These articles shall be proposed to the legislatures of all the United States, to be considered, and if approved of by them, they are advised to authorize their delegates to ratify the same in the Congress of the United States, which being done, the same shall become conclusive.
Compare the Articles to the Constitution.
Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying them.
The Articles were ratified by state legislatures. The Constitution, in contrast, was ratified by special state conventions elected by the people. Nationalists recommended this procedure because it bypassed state legislatures. Nationalists did not want the Constitution to be a creation of state governments. Yet this ratification procedure, like other sections of the Constitution, is ambiguous. It is an example used by Madison when he described the Constitution as neither wholly national nor wholly federal.
On one hand, the Constitution is to be founded on the assent and ratification of the people of America, given by deputies elected for the special purpose. But, on the other, this assent and ratification is to be given by the people, not as individuals composing one entire nation, but as composing the distinct and independent states to which they respectively belong. It is to the assent and ratification of the several states, derived from the supreme authority in each state, the authority of the people themselves. The act, therefore, establishing the Constitution will not be a national but a federal act.
Madison used this argument in the Federalist Papers in his effort to promote ratification of the Constitution. It did not play a significant role, however, during the Constitutional Convention. There, nationalists were clear that ratification was to be by the people, not by the states. Nationalists realized that circumventing state legislatures was tantamount to circumventing the states themselves. A constitution ratified by the people was extremely important to nationalists. If people rather than states were parties to the American Union, then the national government, in enforcing its laws, could operate directly on those people. In the Articles of Confederation, the federal government could operate only against states. This, at least, was the theory of the Articles. During the convention, when defenders of federalism pointed to the Articles as their model, Madison replied that even the Articles permitted the Confederation Congress to operate directly on individuals in some cases. Madison was right, but his examples were exceptions to the rule. The principle involved here is illustrated by the way the Confederation Congress raised money. After authorizing the Confederation Congress to determine the funds required for the common defense and general welfare, the Articles of Confederation continue.
The taxes for paying that proportion shall be laid and levied by the authority and direction of the legislatures of the several states, within the time agreed upon by the United States in Congress assembled.
In other words, the Confederation Congress would requisition money from the states, and the states would raise this money by taxing their citizens. The federal government dealt with states, not with individuals. Incidentally, this provision was the most severely criticized part of the Articles. While authorizing Congress to requisition the states for money, The Articles failed to authorize a method to enforce these requisitions. The Confederation Congress could do little more than request money from the states, and, as we might expect, such requests often fell flat. When convention delegates were instructed to amend and correct the Articles of Confederation, a top priority was to vest Congress with the power to enforce requisitions, but this power became unnecessary. A national government was not required to operate through the medium of state governments. It could tax individuals directly, as the Constitution says.
Article 1, Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the general welfare of the United States.
We have examined several differences between the Constitution and the Articles of Confederation. How did Americans in the 1780s view these differences? Did they see the Constitution as a radical departure from the Articles, or did they see the Constitution as an extension and elaboration of principles already contained in the Articles? Then as now, the answer depends on who you listen to. Perhaps we should consult the father of the Constitution himself, James Madison. The Constitution, Madison wrote in the Federalist Papers, was a fundamental departure from the Articles of Confederation.
The novelty of the undertaking immediately strikes us. It has been shown in the course of these papers that the existing Confederation is founded on principles which are fallacious, that we must consequently change this first foundation, and with it the superstructure resting upon it.
In this passage, Madison is crystal clear, but confusion sets in when we consult another passage from the Federalist Papers.
The truth is that the great principles of the Constitution proposed by the Convention may be considered less as absolutely new than as the expansion of principles which are found in the Articles of Confederation.
Here the Constitution is portrayed as an expansion of principles already contained in the Articles. Did Madison contradict himself? Well, perhaps not. Perhaps by the great principles of the Constitution, Madison meant the basic philosophical and political principles upheld by most 18th century Americans. These were the famous principles articulated by Thomas Jefferson in the Declaration of Independence.
We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness.
According to Madison and other nationalists, these principles were embodied in the Constitution. According to the defenders of state sovereignty, these principles already were embodied in state constitutions. Consider, for example, the Constitution of New Hampshire, ratified in 1784. This state constitution expounds principles familiar to 18th century Americans.
All men are born equally free and independent. Therefore, all government of right originates from the people, is founded in consent, and instituted for the general good.
After asserting that men have certain natural, essential, and inherent rights, the New Hampshire Constitution articulates a theory known as the social contract.
When men enter into a state of society, they surrender up some of their natural rights to that society in order to ensure the protection of others, and without such an equivalent, the surrender is void.
Americans were indebted for their version of social contract theory to the 17th century English philosopher John Locke. According to this theory, individuals voluntarily leave a state of nature, as Locke called it, to form a civil society. In so doing, individuals relinquish some of their rights to a government in order to protect the rest of their rights. This theory was used to justify the sovereignty of state governments, and it also was used to justify the sovereignty of the national government established by the Constitution. Defenders of state sovereignty and defenders of national sovereignty began with the same theory, but they reached different conclusions. Why? Part of the reason may be seen in a debate during the Constitutional Convention. Luther Martin, the Attorney General of Maryland, was a vocal defender of state sovereignty. At the time of the Revolution, Martin argued, the American states had become independent entities, or, using the terms of social contract theory, they had been placed in a state of nature.
The separation from Great Britain placed the 13 states in a state of nature towards each other, and they would have remained in that state till this time but for the Confederation. The American states entered into the Confederation on the footing of equality, and they now mean to amend it on the same footing.
The nationalist James Wilson, a Scottish immigrant, disagreed. The American states had declared their independence collectively, not individually. Therefore, Wilson argued, the states had never been completely independent from one another.
I cannot admit the doctrine that when the colonies became independent of Great Britain, they became independent also of each other. According to the Declaration of Independence, the United Colonies were declared to be free and independent states. I infer from this that they were independent, not individually, but unitedly.
James Madison, writing in the Federalist Papers, tried to cut through this Gordian knot of political theory. According to Madison, the true worth of the Constitution should be measured not by its federal or national characteristics, but by its ability to maintain a republican form of government.
It is evident that no other form would be reconcilable with the genius of the people of America, with the fundamental principles of the Revolution, or with that honorable determination which animates every votary of freedom to rest all our political experiments on the capacity of mankind for self-government.
What is a republic, according to Madison?
If we resort for a criterion to the different principles on which different forms of government are established, we may define a republic to be, or at least may bestow that name on, a government which derives all its powers directly or indirectly from the great body of the people, and is administered by persons holding their offices during pleasure for a limited period or during good behavior.
A republic, Americans agreed, is a government of the people. But republics were something of a novelty in the 18th century, and there was considerable disagreement over how a republic should be structured. One thing was clear, however: a republic is not a pure democracy. A republic, if it is to protect individual rights, must protect minorities from unlimited majority rule. A majority, as John Adams said, can be as tyrannical as any despot.
We may appeal to every page of history we have hitherto turned over for proofs irrefragable that the people, when they have been unchecked, have been as unjust, tyrannical, brutal, barbarous, and cruel as any king or senate possessed of uncontrollable power. The majority has eternally, and without one exception, usurped over the rights of the minority.
America's founding fathers, however much they disagreed on some issues, held similar views of human nature. Human beings, they believed, are motivated primarily by self-interest. This powerful motive leads to good consequences in economic interaction, but it becomes extremely dangerous in politics, where some men are given power over others. 18th century Americans spoke often and eloquently about the corrupting tendency of political power. The ambition and lust of power, declared Samuel Adams, are predominant passions in the breasts of men. Americans compared power to a grasping hand and to a liquor intoxicating in its nature. Power, it was said, converts a good man in private life to a tyrant in office. When self-interest is unchecked in the realm of power, Americans believe tyranny will inevitably follow, and this tyranny can spring from the one, from the few, or from the many. This was the primary objection to a pure democracy, that is, a democracy with no checks on the power of the majority. Again, quoting John Adams.
An excellent writer has said, somewhat incautiously, that a people will never oppress themselves or invade their own rights. This compliment, if applied to human nature or to mankind, or to any nation or people in being or in memory, is more than has been merited. If it should be admitted that a people will not unanimously agree to oppress themselves, it is as much as is ever and more than is always true. All kinds of experience show that great numbers of individuals do oppress great numbers of other individuals, that parties often, if not always, oppress other parties, and majorities almost universally minorities. All that this observation can mean, then, consistently with any color of fact, is that the people will never unanimously agree to oppress themselves. But if one party agrees to oppress another, or the majority the minority, the people still oppress themselves, for one part of them oppress another.
Here, then, is a basic problem confronting a republic, a government by the people. How can the people be prevented from abusing power? A traditional answer, an answer employed by European monarchies, was simply to grant the people little power, or no power at all. Monarchs and princes would shepherd their flocks in the path of virtue, wisdom, and social order. Of course, Americans reared in a revolutionary tradition weren't going to accept this rationale for despotism. Therefore, they searched for a middle ground between pure democracy on the one extreme and absolute government on the other extreme. They found the answer in a republican form of government. This kind of government, limited in its scope, is structured to inhibit the abuse of power. This structure includes a separation of governmental powers, and this separation, in turn, leads to a system of checks and balances. In eloquent fashion, Madison summarized the danger arising from the self-interested pursuit of power, and he suggested a remedy.
The great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. The provision for defense must in this, as in all other cases, be made commensurate to the danger of attack. Ambition must be made to counteract ambition. The interest of the man must be connected with the constitutional rights of the place. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government, which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place oblige it to control itself. A dependence on the people is, no doubt, the primary control on the government. But experience has taught mankind the necessity of auxiliary precautions.
Madison believed the Constitution includes these auxiliary precautions. The Constitution separates power into three categories, and then it distributes this power among three branches of government.
Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Article 2, Section 1. The executive power shall be vested in a President of the United States of America. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish.
This is the famous separation of powers doctrine. This theory has a long and complicated history. It was discussed by ancient Greek philosophers and historians. But the principal influence on the framers of the Constitution was the 18th century French philosopher Montesquieu. As Madison said,
"The oracle, who is always consulted and cited on this subject, is the celebrated Montesquieu. If he be not the author of this invaluable precept in the science of politics, he has the merit, at least, of displaying and recommending it most effectually to the attention of mankind."
Here is a passage from Montesquieu's famous book, Spirit of the Laws, published in 1748.
There would be an end of everything, were the same man or the same body, whether of the nobles or of the people, to exercise those three powers, that of enacting laws, that of executing the public resolutions, and of trying the causes of individuals.
For Montesquieu, the English system of government exemplified the separation of powers. In practice, he conceded, the English system did not always preserve individual liberty. But in its basic structure, the English system was an ideal model. Another writer who influenced framers of the Constitution was the 18th century English jurist Sir William Blackstone. His Commentaries on the Laws of England was a standard legal text, and it was well known among the many convention delegates who were lawyers. Blackstone explained how a separation of powers in the English government checked the abuse of power.
As this aggregate body, actuated by different springs and attentive to different interests, composes the British Parliament and has the supreme disposal of everything, there can no inconvenience be attempted by either of the three branches, but will be withstood by one of the other two, each branch being armed with a negative power, sufficient to repel any innovation which it shall think inexpedient or dangerous.
Most Americans believe strongly in the separation of governmental powers. This was one reason they criticized the Articles of Confederation. The Articles established a legislative body, the Confederation Congress, but they failed to establish separate executive and judiciary branches. Even critics of the Constitution usually applauded its distribution of powers among three branches. Some critics, however, accused the Constitution itself of violating the separation of powers doctrine. For example, this was a major concern of Richard Henry Lee, the distinguished Virginian who made the original resolution for American independence in the Second Continental Congress.
It has hitherto been supposed a fundamental maxim that in governments rightly balanced, the different branches of the legislature should be unconnected, and that the legislative and executive powers should be separate. In the new Constitution, the President and Senate have all the executive and 2/3 of the legislative power. In some weighty instances, as making all kinds of treaties which are to be the laws of the land, they have the whole legislative and executive powers. They jointly appoint all officers, civil and military, and they, the Senate, try all impeachments either of their own members or of the officers appointed by themselves.
In the Federalist Papers, James Madison conceded the importance of this objection.
The accumulation of all powers, legislative, executive, and the judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. Were the federal Constitution, therefore, really chargeable with this accumulation of power, or with a mixture of powers, having a dangerous tendency to such an accumulation, no further arguments would be necessary to inspire a universal reprobation of the system.
As we have seen, the primary source used by 18th century Americans for the separation of powers doctrine was the French philosopher Montesquieu. Madison claimed this philosopher had been misinterpreted by critics of the Constitution. According to Montesquieu, legislative, executive, and judicial powers should not be united in the same person or body of persons. This, Madison argued, does not mean governmental departments should be wholly unconnected.
Montesquieu did not mean that these departments ought to have no partial agency in or no control over the acts of each other. His meaning can amount to no more than this, that where the whole power of one department is exercised by the same hands which possess the whole power of another department, the fundamental principles of a free constitution are subverted.
A separation of powers is the foundation for a system of checks and balances, but this system is possible only if governmental departments overlap in some areas. Otherwise, they could not restrain each other.
Unless these departments be so far connected and blended as to give to each a constitutional control over the others, the degree of separation, which the maxim requires as essential to a free government, can never in practice be duly maintained.
According to Madison, all defenders of liberty agree on the need for a separation of powers. The real difficulty lies in establishing an effective system of checks and balances.
It will not be denied that power is of an encroaching nature, and that it ought to be effectually restrained from passing the limits assigned to it. After discriminating, therefore, in theory, the several classes of power, as they may in their nature be legislative, executive, or judiciary, the next and most difficult task is to provide some practical security for each against the invasion of the others. What this security ought to be is the great problem to be solved.
How does the Constitution solve this great problem, as Madison called it? What are its major provisions for a system of checks and balances? We shall now turn to these questions. Several parts of the Constitution deal with the legislative power to remove officials of the federal government. These officials may belong to any of the three branches of government, but as we shall see, framers of the Constitution had the President foremost in mind when approving this power. Thus, the power of removal is commonly seen as a check by the legislative branch against the executive branch. Removal from office involves two stages, impeachment and trial. To impeach means to accuse, to bring charges. The Constitution provides for the impeachment and trial of federal officials.
Article 2, Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors.
The power of impeachment has roots deep in English history, reaching back to the 14th century. The phrase treason, bribery, and other high crimes and misdemeanors also has roots deep in English history. These words were familiar to any student of English law in the 18th century. The Constitution also follows the English model in placing the power of impeachment in the lower house. In England, this is the House of Commons. In America, the House of Representatives.
Article 1, Section 2. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment.
After charges are brought, the Senate acts as the trial court.
Article 1, Section 3. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present.
In the Federalist Papers, Alexander Hamilton pointed to the English precedent of impeachments and trials of impeachment. And though the power of impeachment and trial extends to all federal officials, Hamilton identified the primary target of this power, the executive branch. Thus, in America, this legislative power was intended primarily as a legislative check on the abuse of power by the President.
The model from which the idea of this institution has been borrowed pointed that course to the Convention. In Great Britain, it is the province of the House of Commons to prefer the impeachment, and of the House of Lords to decide upon it. As well, the latter as the former seem to have regarded the practice of impeachments as a bridle in the hands of legislative body upon the executive servants of the government. Is not this the true light in which it ought to be regarded?
After a president is impeached by the House, he is tried by the Senate. This power of the Senate occasioned some debate during the Constitutional Convention. James Madison and others believed trials of impeachment should be conducted not by the Senate, but by the Supreme Court, or at least by some tribunal of which the Supreme Court forms a part. South Carolina's Charles Pinckney gave the reasoning behind this position.
I disapprove of making the Senate the court of impeachments, as rendering the president too dependent on the legislature. If he opposes a favored law, the two houses will combine against him, and under the influence of heat and faction, throw him out of office.
Connecticut's Roger Sherman disagreed. Trial by the Supreme Court, he believed, would entail a conflict of interests.
I regard the Supreme Court as improper to try the president because the judges would be appointed by him.
Other delegates favored the Senate because it contains more members than the Supreme Court. The more persons involved in the trial of a president, they believed, the less chance of corruption affecting the outcome. Alexander Hamilton echoed this reason in the Federalist Papers.
The awful discretion which a court of impeachments must necessarily have to doom to honor or to infamy the most confidential and the most distinguished characters of the community forbids the commitment of the trust to a small number of persons.
In conducting trials of impeachment, the Senate, a part of the legislative branch, acts as a judicial body. Doesn't this violate the separation of powers? No, according to Hamilton. Like Madison, Hamilton argued that a separation of powers does not mean governmental departments should never overlap. Indeed, without this occasional intermixture, the system of checks and balances could not operate.
This partial intermixture is even, in some cases, not only proper but necessary to the mutual defense of the several members of the government against each other.
The crimes leading to impeachment, Hamilton explained, are distinctly political crimes, that is, crimes against society as a whole. If a president is impeached and convicted, his punishment is removal from office, along with the disgrace this causes. Conviction does not carry civil or criminal penalties. These must be tried separately, and this is where a president falls within the power of the judiciary.
Article 1, Section 3. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law.
The Constitution contains one other reference to impeachment, and the reasoning behind it is obvious. The first clause of Article 2, Section 2 reads, in part,
The President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment.
The Constitution vests power in the President to veto legislative acts. Now, this is another important feature of checks and balances. The presidential veto, like many issues relating to executive power, was a touchy subject for convention delegates. After all, only 4 years had passed since the Treaty of Paris had officially ended the American Revolution. For what had Americans spent their blood and money? For many Americans, the war was fought not just against a particular monarch, George III, but against the principles of monarchy itself. Let it be known, declared Thomas Paine in his famous pamphlet Common Sense, that in America law is king, and there is to be no other. For many delegates, the hated principles of monarchy included far more than the hereditary transfer of power. Essential to monarchy, in their eyes, was a single executive vested with strong powers which he could exercise virtually at his discretion. Thus, some delegates, such as Virginia's George Mason and Governor Edmund Randolph, even opposed a single executive, calling it the fetus of monarchy. These delegates called instead for a plural executive, an executive council instead of a single president. On the other extreme were delegates who vigorously defended a single executive with strong powers. Alexander Hamilton, for example, desired a president elected for life with the power to appoint the governors of every state. This is one reason why Thomas Jefferson, many years after the convention, accused Hamilton of favoring the principles of monarchy. The issue of a presidential veto, or as delegates called it, an executive negative, was especially sensitive during convention debates. The reason for this is illustrated in the Declaration of Independence. Among the many charges leveled against George III, his absolute veto power over laws passed by American legislatures was mentioned first.
He has refused his assent to laws, the most wholesome and necessary for the public good.
American distrust of executive power ran deep. Among the three branches of government, the executive usually was feared as the greatest threat to liberty. The legislative branch, on the other hand, was often seen as the repository of liberty. Thus, any constitutional provision granting an executive veto over legislative acts was sure to raise American eyebrows. The original convention plan for an executive veto tried to soften the blow by including a portion of the national judiciary in the veto process. This went nowhere. Then two champions of executive power, James Wilson and Alexander Hamilton, moved to give the president absolute veto power, that is, a veto that cannot be overridden by the legislature. Before this proposal went down to unanimous defeat, its two advocates were reminded by Virginia's George Mason that Americans would never tolerate a monarch, not even an elected one. The Constitution incorporated this American hostility to the trappings of monarchy. A clause from Article 1, Section 9 reads,
"No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, except of any present, emolument, office, or title of any kind whatever, from any king, prince, or foreign state."
The final presidential veto was something of a compromise, but on the whole it was a significant victory for champions of executive power. The president can veto laws passed by the legislature, but this is a qualified veto. It can be overridden by a two-thirds majority in each branch of the legislature.
Article 1, Section 7. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it. But if not, he shall return it, with his objections, to that House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If, after such reconsideration, two-thirds of that House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be reconsidered, and if approved by two-thirds of that House, it shall become a law. But, in all such cases, the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by two-thirds of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill.
Revolutionary Americans had a deep suspicion of executive powers. For example, the Articles of Confederation, ratified in 1781, did not even establish an executive branch at all. Why, then, was a strong veto power included in the Constitution 6 years later? A lot happened in America between 1781 and 1787, both in the realm of politics and in the realm of political theory. Many Americans believed that post-war America was in the midst of crisis and that the government established by the Articles of Confederation was far too weak to remedy the situation. Most delegates to the Constitutional Convention agreed with this grim assessment. They feared the American Republic was on the verge of collapse, and they generally agreed on the reason for this near failure. America, delegates repeatedly declared, suffered from an excess of democracy. Here are some typical examples. Roger Sherman from Connecticut.
The people immediately should have as little to do as may be about the government. They lack information and are constantly liable to be misled.
Elbridge Gerry from Massachusetts.
The evils we experience flow from an excess of democracy. The people do not lack virtue, but are dupes of pretended patriots.
Governor Edmund Randolph from Virginia.
The general object of this convention is to provide a cure for the evils under which the United States labors, and in tracing these evils to their origin, every man has found it in the turbulence and follies of democracy.
In the Federalist Papers, James Madison reinforced this point with his characteristic lucidity.
Liberty may be endangered by the abuses of liberty, as well as by the abuses of power. And there are numerous instances of the former as well as of the latter. The abuse of liberty, rather than the abuse of power, is apparently most to be apprehended by the United States.
A number of important features of the Constitution, including the presidential veto, were designed to check the abuses of liberty, or the imprudence of democracy, as Alexander Hamilton called it. This was one reason the Constitution was attacked by critics as a betrayal of the American Revolution. In the strong language of Richard Henry Lee,
"It will be considered, I believe, as a most extraordinary epoch in the history of mankind, that in a few years there should be so essential a change in the minds of men. 'Tis really astonishing that the same people who have just emerged from a long and cruel war in defense of liberty should now agree to fix an elective despotism upon themselves and their posterity."
Some modern historians agree with Lee's analysis. The American Revolution, these historians argue, led to the creation of state governments which in many cases were more democratic than the Constitution. Nationalists and other convention delegates were disturbed by these democratic state assemblies because the wrong kind of men were getting elected, men who often hailed from the lower rungs of American society. Thus, according to this interpretation, convention delegates sought to curb the power of state governments, claiming they led to democratic excesses. Some defenders of the Constitution admitted it departed from the principles of the American Revolution. Naturally, however, these defenders portrayed the change in a favorable light. During revolutionary times, they argued, Americans had adopted some mistaken views about democracy and a republican form of government, and these views had caused economic and political chaos. The Constitution, its supporters claimed, corrected these errors. Alexander Hamilton discussed this in the Federalist Papers. Like James Madison and other Americans, Hamilton believed the American Republic was on a downward spiral to anarchy. Why? Because, he argued, prior to the Constitution, Americans had relied too much on the principles of ancient republics. These republics invariably failed because they did not institute safeguards against the turbulence of unlimited majority rule. But political science had made great strides in modern times. Hamilton believed the Constitution incorporated these new and better principles. It was based on an up-to-date science of politics.
The science of politics, like most other sciences, has received great improvement. The efficacy of various principles is now well understood, which were either not known at all or imperfectly known to the ancients. The regular distribution of power into distinct departments, the introduction of legislative balances and checks, the institution of courts composed of judges holding their offices during good behavior, the representation of the people in the legislature by deputies of their own election. These are wholly new discoveries, or have made their principal progress in modern times. They are means, and powerful means, by which the excellencies of republican government may be retained, and its imperfections lessened or avoided.
James Madison agreed with Hamilton. Madison believed Americans had traditionally placed too much trust in the legislative branch. The executive veto was necessary, according to Madison, because legislative tyranny can destroy republics. Referring to earlier defenders of republics, Madison commented,
"They seem never to have recollected the danger from legislative usurpations which, by assembling all powers in the same hands, must lead to the same tyranny as is threatened by executive usurpations."
Framers of the Constitution were troubled by the excesses of democracy in America, that is, the absence of sufficient checks on the power of majorities. This concern was part of their reason for instituting a bicameral, or two-house legislature. The House of Representatives was seen as the Democratic branch. Representatives, according to the Constitution, are elected by the people every 2 years.
Article 1, Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature.
Many delegates viewed the Senate as a check on the excesses of the popularly elected House. Senators served for 6 years, not 2, and until the 17th Amendment was ratified in 1915, senators were elected by the legislatures of individual states, not by the people.
Article 1, Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote.
The Senate, as we said, was intended to check the House of Representatives. James Kent, in his Commentaries on American Law, explained the reasoning behind this. Kent was appointed Chief Justice of New York Supreme Court in 1804, and he later became a professor of law at Columbia University. His commentaries are regarded as one of the most important works on legal theory ever published in America. Kent's remarks on the Senate concur with those of Madison, Hamilton, and many other convention delegates.
The small number and long duration of the Senate were intended to render them a safeguard against the influence of those paroxysms of heat and passion which are apt to prevail occasionally in the most enlightened communities, and to enter into the deliberation of popular assemblies. In this point of view, a firm and independent Senate is justly regarded as an anchor of safety amidst the storms of political faction. The legal presumption is that the Senate will entertain more enlarged views of public policy, will feel a higher and juster sense of national character, and a greater regard for stability in the administration of the government.
Why will the Senate exhibit more stability and wisdom than the House of Representatives?
These qualities, it is true, may in most cases be equally found in the other branch of the legislature, but the constitutional structure of the House is not equally calculated to produce them. For as the House of Representatives comes more immediately from the people, and the members hold their seats for a much shorter time, they are presumed to partake with a quicker sensibility of the prevailing temper and irritable disposition of the times, and to be in much more danger of adopting measures with precipitation, and of changing them with levity.
The House of Representatives, elected directly by the people, was likely to shift with the changing winds of majority rule. The Senate, Kent explained, was designed to check this instability.
A disposition to multiply and to change laws upon the spur of the occasion, and to be making constant and restless experiments with the statute code, seems to be the natural disease of popular assemblies. In order, therefore, to counteract such a dangerous propensity, it is requisite that another body of men should be placed as a check upon the intemperance of the more popular department.
The Senate, in addition to checking the House of Representatives, also was designed to check the power of the President. The President is empowered to conduct foreign policy by negotiating treaties, but such treaties must pass the Senate by a two-thirds vote.
Article 2, Section 2. The President shall have power, by and with the advice and consent of the Senate, to make treaties, provided two-thirds of the senators present concur.
Except for the President and Vice President, all members of the executive branch are appointed. The President makes these appointments, and in addition, he appoints justices to the Supreme Court. Again, however, the Senate can check this presidential power. The Senate must approve all appointments of superior officers in the executive branch and all appointments to the Supreme Court.
Article 2, Section 2. The President shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, or in the heads of departments.
We have looked at the role of the executive and legislature in the American system of checks and balances. Now let's examine the role of the federal judiciary, and especially the Supreme Court. Framers of the Constitution, in upholding the separation of powers, considered it essential for federal judges to hold their offices during good behavior. This, in effect, means life tenure. Federal judges can be removed only if convicted of the high crimes and misdemeanors specified in Article 2, Section 4 of the Constitution. The Constitution also provides for judicial independence by prohibiting a reduction of salary during the tenure of a federal judge.
Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation, which shall not be diminished during their continuance in office.
In the Federalist Papers, Alexander Hamilton explained the importance of life tenure for federal judges.
The standard of good behavior for the continuance in office of the judicial magistracy is certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is a no less excellent barrier to the encroachments and oppressions of the representative body. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws.
According to Hamilton, the judiciary is the weakest of the three branches of government. It does not wield the sword, nor does it control the purse. Therefore, to prevent it from being manipulated and intimidated by other branches of government, the judiciary requires total independence. This is especially true if the judiciary is to check the excesses of the legislative branch.
The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all the reservations of particular rights or privileges would amount to nothing.
Doesn't this render the judiciary superior to the legislature? No, Hamilton argued. It merely keeps the legislature within the boundaries of the Constitution.
No legislative act contrary to the Constitution can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid.
Alexander Hamilton, in his discussion of the federal judiciary, defended a theory known today as the doctrine of judicial review. This is the power of federal courts, and ultimately the Supreme Court, to declare laws unconstitutional. It is important to understand that judicial review is never mentioned in the Constitution, at least not explicitly. The Constitution does not vest the Supreme Court with power to assess the constitutionality of laws. Here are the powers expressly granted to the federal judiciary.
Article 3, Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases affecting ambassadors, other public ministers and consuls. To all cases of admiralty and maritime jurisdiction. To controversies to which the United States shall be a party. To controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects.
If the Constitution does not provide for judicial review, how did the Supreme Court acquire this power? We shall now consider this question. When Americans think of the Supreme Court, they often associate it with the power of judicial review, that is, the power to nullify laws by declaring them unconstitutional. This power, however, is not found in the Constitution. According to some legal scholars, the power of judicial review, even if it is not expressly granted by the Constitution, is at least implied by some of its provisions. Other legal scholars disagree. It is difficult to settle this controversy by referring to the Constitutional Convention. Convention delegates did not spend much time discussing specific powers of the federal judiciary. Some delegates seem to have favored a Supreme Court with a power of judicial review, while other delegates seem to have opposed the idea. The Virginia Plan, on which much of the Constitution is based, originally included a provision which hinted at judicial review. The Virginia Plan called for a council of revision consisting of the President and members of the federal judiciary. This council would judge whether state laws conform to the Constitution, and it would be empowered to nullify state laws by declaring them unconstitutional. The proposed council of revision was seen as a serious threat to state sovereignty, and it was voted down. In its place, small state delegates proposed a resolution which, when included in Article 6 of the Constitution, has become known as the Supremacy Clause. This clause, after declaring the Constitution to be the supreme law of the land, goes on to say,
"The judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding."
Notice how this passage refers to state courts, not to federal courts. During the Constitutional Convention, the Supremacy Clause was offered by advocates of state sovereignty as a compromise with nationalists. The Constitution was to be supreme, but the Supremacy Clause left open the possibility that state courts would decide on the constitutionality of laws. This interpretation, had it been accepted, would have left the states with considerable power. State Supreme Courts had long exercised the power of judicial review over the laws of their own states. Now it looked as if these state courts would judge the constitutionality of federal laws as well. If this was a victory for defenders of state sovereignty, their victory was fairly short-lived. Article 1, Section 8 of the Constitution empowers Congress to constitute tribunals inferior to the Supreme Court, and this is exactly what Congress did a year after the Constitution was ratified. In the famous Judiciary Act, of 1789. The Judiciary Act structured the federal judiciary more or less as we know it today. It established a three-tiered system of federal courts, the district, circuit, and Supreme Courts. And in Section 25, the Judiciary Act allowed Americans to appeal some decisions from state courts to the Supreme Court if constitutional issues were involved. Now, this was the first major step in vesting the federal Supreme Court with the power of judicial review. The Judiciary Act rendered state courts subordinate to federal courts in a manner not expressly stated in the Constitution. During its early years, the Supreme Court sometimes issued decisions which implied the power of judicial review. In those years, however, the Supreme Court had 6 justices, and each justice delivered a separate opinion. Thus, there was no dominant voice or majority decision in which the power of judicial review could germinate and grow. All this changed after John Marshall was appointed Chief Justice in 1801. Marshall inaugurated the practice of issuing a majority decision, thus allowing the Supreme Court to speak with a unified and powerful voice. And in 1803, in the complex and controversial case of Marbury v. Madison, Chief Justice Marshall forever embedded judicial review into American law. Marshall mapped out 2 possibilities. Either the Constitution is the fundamental law of the land, or it is not.
Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall please to alter it. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable.
The purpose of a written constitution, declared Marshall, is to establish fundamental and supreme laws. Clearly, this means that any legislative act contrary to the Constitution is void and without effect. What, then, should the Supreme Court do when confronted with an unconstitutional law?
It is emphatically the province and duty of the Judicial Department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If 2 laws conflict with each other, the court must decide on the operation of each.
According to Marshall, the power of judicial review is implicitly contained in the United States Constitution.
The judicial power of the United States is extended to all cases arising under the Constitution. Could it be the intention of those who gave this power to say that in using it, the Constitution should not be looked into? That a case arising under the Constitution should be decided without examining the instrument under which it arises? This is too extravagant to be maintained. In some cases, then, the Constitution must be looked into by the judges. And if they can open it at all, what part of it are they forbidden to read or to obey?
Marshall stated his conclusion with force and clarity.
Thus the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument.
John Marshall's decision in Marbury v. Madison is the cornerstone of judicial review by the Supreme Court. And Marbury v. Madison, we should note, was a case fraught with political implications. In 1800, Thomas Jefferson defeated John Adams for the presidency, and Jefferson's party won control of the Congress. Before Jefferson took office in 1801, however, his political opponents tried to solidify their control of the judiciary. They passed a Judiciary Act in 1801, which created new federal judgeships, and then Adams packed these positions with party loyalists. In addition to these midnight appointments, as they were called, this Judiciary Act also reduced the number of Supreme Court justices from 6 to 5. This was to lessen the possibility of Jefferson appointing a justice during his presidency. Finally, and most importantly, Adams appointed his Secretary of State, John Marshall, to the position of Chief Justice of the Supreme Court. The landmark case of Marbury v. Madison arose from this political struggle to control the federal judiciary. Did John Marshall act as an impartial, objective judge, or did John Marshall act as a political partisan who wished to strengthen a federal judiciary filled with opponents of Thomas Jefferson? As always, historians disagree. Historical mind-reading is at best a hazardous enterprise. But for the record, we should note that John Marshall, the champion of judicial review, seemed to have entertained different views in his earlier years. In 1788, a 33-year-old John Marshall served as a member of the Virginia Ratifying Convention. In defending the proposed Constitution, Marshall tried to reassure critics that the federal judiciary would not encroach on state sovereignty.
In disputes between a state and the citizens of another state, I hope that no gentleman will think that a state will be called at the bar of a federal court. It is not rational to suppose that the sovereign power of a state should be dragged before a court.
In 1790, shortly after the Constitution had been ratified, there were approximately 700,000 slaves in the United States, almost 20% of America's total population. By 1860, the number of slaves had swollen to 4 million. In 1865, the 13th Amendment to the Constitution abolished slavery in America.
Neither slavery nor involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction.
During the 1840s and 50s, many anti-slavery radicals, or abolitionists as they were called, pointed an accusing finger at the Constitution. The Constitution, they argued, while supposedly a citadel of liberty, actually supported the hideous institution of slavery. John Quincy Adams, 6th President of the United States, put the matter bluntly.
Yes, it cannot be denied. The slave-holding lords of the South prescribed, as a condition to their assent to the Constitution, 3 special provisions to secure the perpetuity of their dominion over their slaves. The first was the immunity for 20 years of preserving the African slave trade. The second was the stipulation to surrender fugitive slaves, an engagement positively prohibited by the laws of God. And thirdly, the exaction, fatal to the principles of popular representation, of a representation for slaves, for articles of merchandise under the name of persons. In fact, the oppressor representing the oppressed. To call government thus constituted a democracy is to insult the understanding of mankind.
Although the words slave and slavery never appear in the Constitution, 10 clauses support it, directly or indirectly. We shall focus on the most important of these. The first reference to slavery is the 3rd clause of Article 1, Section 2. Here, slaves are discreetly referred to as all other persons.
Article 1, Section 2. Representatives and direct taxes shall be apportioned among the several states which may be included within this Union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons.
This is the famous 3/5 rule, whereby a slave was counted as 3/5 of a person when calculating the number of representatives allotted to states. After stating this rule, the Constitution demands that a census be taken every 10 years in order to assign the proper number of representatives.
Article 1, Section 2. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct.
Thus, when a census was taken, 5 slaves were counted as the equivalent of 3 persons for the purpose of assigning representatives. This 3/5 rule increased the power of slave states in the House of Representatives and so was to play a major role in American politics until the Civil War. The 3/5 rule was familiar to convention delegates. Known as the federal ratio, it had been used since 1783 to apportion taxes among states. The federal ratio of 3/5 was included in the Constitution as part of complicated negotiations and compromises over proportional representation, that is, representation based on population. Large states desired proportional representation in both branches of the national legislature. Small states, fearing domination by their larger neighbors, desired equal representation for all states in both branches. This was the most significant conflict during the Constitutional Convention, and it finally was resolved on July 16th in what is known as the Great Compromise. This agreement called for proportional representation in the House of Representatives and for equal representation of states in the Senate.
Article 1, Section 2. Representatives and direct taxes shall be apportioned among the several states which may be included in this Union, according to their respective numbers. Article 1, Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator shall have 1 vote.
For many delegates, the clash of interests between big states and small states loomed as the most significant problem confronting the future of America. But James Madison disagreed. On the 14th of July, while the convention was debating representation in the Senate, Madison rose to defend proportional representation. The real conflict facing America, he prophetically asserted, was not between large states and small states. Rather, the conflict was between northern states and southern states. The dividing line, Madison declared, was slavery.
It seems now to be pretty well understood that the real difference of interest lays not between the large and the small, but between the northern and southern states. The institution of slavery and its consequences form the line of discrimination. There are 5 states on the southern, 8 on the northern side of the line. Should a proportional representation take place, it is true the northern would still outnumber the other, but not in the same degree at this time, and every day would tend towards an equilibrium.
James Madison, though a slave owner, was philosophically opposed to slavery. This caused him some embarrassment when he defended the 3/5 rule in the Federalist Papers. There, Madison placed quotation marks around his defense of the 3/5 rule. He then went on to say,
"Such is the reasoning which an advocate for the Southern interests might employ on this subject, and although it may appear to be a little strained in some points, yet, on the whole, I must confess that it fully reconciles me to the scale of representation which the Convention have established."
Like other slavery provisions in the Constitution, the 3/5 rule was required to bring the Deep South into the American Union. As Madison put it in a letter to Thomas Jefferson, South Carolina and Georgia were inflexible on the point of slaves. Early in the Constitutional Convention, Pennsylvania's James Wilson proposed a compromise on slavery and representation. He suggested incorporating the 3/5 rule in the Constitution. Weeks later, however, Wilson had second thoughts.
I do not well see on what principle the admission of blacks in the proportion of 3/5 can be explained. Are they admitted as citizens? Then why are they not admitted on an equality with white citizens? Are they admitted as property? Then why is not other property admitted into the computation? These are difficulties, however, which I think must be overruled by the necessity of compromise.
Wilson, like many delegates, was philosophically opposed to slavery, but he was not free of the racism endemic in 18th century America. One of Wilson's arguments against the 3/5 rule displays an attitude that, unfortunately, was common among delegates. White Americans, Wilson contended, would object to being included in the same census with blacks.
I have some apprehensions also from the tendency of the blending of the blacks with the whites to give disgust to the people of Pennsylvania as has been intimated by my colleague, Mr. Gouverneur Morris.
Pennsylvania's Gouverneur Morris had indeed protested the 3/5 rule because white citizens would object to being classified with blacks. It is to Morris's credit, however, that he delivered the convention's most vitriolic attack on slavery.
I will never concur in upholding domestic slavery. It is a nefarious institution. It is the curse of heaven on the states where it prevails. Upon what principle is it that the slave shall be computed in the representation? Are they men? Then make them citizens and let them vote. Are they property? Why, then, is no other property included? The houses in Philadelphia are worth more than all the wretched slaves who cover the rice swamps of South Carolina. The admission of slaves into the representation, when fairly explained, comes to this: that the inhabitant of Georgia and South Carolina, who goes to the coast of Africa and in defiance of the most sacred laws of humanity tears away his fellow creatures from their dearest connections and damns them to the most cruel bondage, shall have more votes in a government instituted for the protection of the rights of mankind than the citizen of Pennsylvania or New Jersey who views with a laudable horror so nefarious a practice.
Some Southern delegates demanded that slaves be counted as full persons when computing representation. As South Carolina's Charles Pinckney put it,
I move to make blacks equal to whites in the ratio of representation. This is nothing more than justice. The blacks are the laborers, the peasants of the Southern states. They are as productive of pecuniary resources as those of the Northern states. They add equally to the wealth, and considering money as the sinew of war, to the strength of the nation.
This proposal would never fly in the convention. Pro-slavery delegates would have to compromise. But the federal ratio was their bottom line. North Carolina's William Davie issued the ultimatum: include the 3/5 rule or forget about support from the Deep South for a new Constitution.
It is high time to speak out. Some gentlemen mean to deprive the Southern states of any share of representation for their blacks. I am sure that North Carolina will never confederate on any terms that do not rate them at least as 3/5. If the Eastern states mean, therefore, to exclude them altogether, the business is at an end.
Thus slavery, that peculiar institution, as Americans euphemistically called it, was embedded in the United States Constitution. This was the price paid for an American Union. But the slavery compromise did not end with the 3/5 rule. The power to tax, it has been said, is the power to destroy. If the federal government had been empowered to levy special taxes on slaves, the future of the peculiar institution might have been jeopardized. This concern of pro-slavery delegates generated a clause in Article 1, Section 9 of the Constitution.
Article 1, Section 9. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken.
This provision ties direct taxes to the census taken every decade. The word capitation means numbering or assessing by the head. A capitation tax, also known as a poll tax, might have enabled the federal government to cripple slavery through special taxes on slaves. Therefore, in linking capitation and other direct taxes to the census, where slaves were counted as 3/5 of a person, slave owners were assured that taxes on slaves would be limited to this ratio. Pro-slavery delegates were concerned about the slave trade. Would the Constitution prohibit the importation of new slaves from Africa? This subject provoked spirited debate during the Constitutional Convention. A preliminary version of the Constitution, reported by the Committee of Detail on August 6th, placed no restraints on the slave trade, and it prohibited the federal government from taxing imported slaves. When these provisions were debated over 2 weeks later, Maryland's Attorney General Luther Martin spoke out against the slave trade.
It is inconsistent with the principles of the Revolution and dishonorable to the American character to allow the slave trade in the Constitution.
South Carolina's John Rutledge was not interested in this moralizing.
Religion and humanity have nothing to do with this question. Interest alone is the governing principle with nations. The true question at present is whether the Southern states shall or shall not be parties to the Union. The people of North Carolina, South Carolina, and Georgia will never be such fools as to give up so important an interest.
George Mason, like James Madison, George Washington, and other delegates from the Upper South, was a peculiar critic of the peculiar institution. Mason was a slave owner who opposed slavery. He wanted a constitutional ban on the detested slave trade.
Every master of slaves is born a petty tyrant. They bring the judgment of heaven on a country. As nations cannot be rewarded or punished in the next world, they must be in this. By an inevitable chain of causes and effects, Providence punishes national sins by national calamities. I lament that some of our Eastern brethren have, from a lust of gain, embarked in this nefarious traffic. As to the states being in possession of the right to import, this is the case with many other rights now to be properly given up. I hold it essential in every point of view that the general government should have power to prevent the increase of slavery.
Connecticut's Oliver Ellsworth, the future Chief Justice of the Supreme Court, pointed out the dilemma in this argument. If the slave trade should be prohibited on moral grounds, then domestic slavery should be banned for the same reason. And, as Ellsworth well knew, no delegate was sufficiently removed from the real world of politics to call for the complete abolition of slavery.
I have never owned a slave, so I cannot judge of the effects of slavery on character. However, if slavery is to be considered in a moral light, we ought to go further and free those slaves already in the country.
When delegates from the Upper South called for banning the slave trade, Ellsworth scented hypocrisy. The economy of the Upper South, he pointed out, did not require newly imported slaves. The economy of the Deep South, however, required their continued importation. Why? Because in the Deep South, harsh conditions killed off slaves rapidly.
As slaves multiply so fast in Virginia and Maryland, it is cheaper to raise than import them, whilst in the sickly rice swamps, foreign supplies are necessary. If we ban the slave trade, we shall be unjust towards South Carolina and Georgia. Let us not intermeddle.
Ellsworth, like many delegates, soothed his conscience with the belief that American slavery was a doomed institution.
As population increases, poor laborers will be so plentiful as to render slaves useless. Slavery in time will not be a speck in our country. Provision is already made in Connecticut for abolishing it, and the abolition has already taken place in Massachusetts.
South Carolina's Charles Cotesworth Pinckney, elder second cousin of another delegate named Charles Pinckney, injected more economic realism into this debate.
South Carolina and Georgia cannot do without slaves. As to Virginia, she will gain by stopping the importations. Her slaves will rise in value, and she has more than she wants. It would be unequal to require South Carolina and Georgia to confederate on such unequal terms. In addition, the importation of slaves will be for the interest of the whole Union. The more slaves, the more produce to employ the carrying trade, the more consumption also, and the more of this, the more revenue for the common treasury.
The outcome of these debates is contained in Article 1, Section 9 of the Constitution. This clause prohibits the federal government from interfering in the slave trade for 20 years.
Article 1, Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importations, not exceeding $10 for each person.
The use of the word migration in this passage is surely the greatest understatement in the Constitution. History has yet to record a single instance of an African who migrated to America to sign up as a slave. Language aside, however, the slave trade provision allowed pro-slavery delegates to return home and claim victory. They had secured a 20-year guarantee of non-interference by the federal government, and they got a bonus to boot. Article 5 authorizes amendments to the Constitution, but it contains important exceptions.
Provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article.
The clauses referred to here are the 20-year sanction of the slave trade and the previously mentioned capitation tax on slaves. These provisions were sheltered from change for 20 years. No other provisions in the Constitution received this immunity. As expected, critics of the Constitution pounced on its 20-year sanction of the slave trade. One of them asked,
"In a serious hour, and in the presence of the Governor of the universe, what reasonable excuse can be made for permitting, and that constitutionally, depredations on a distant and inoffensive people for the term of 20 years?
Anti-slavery defenders of the Constitution made the best of a bad situation. After 20 years, they argued, the slave trade probably would be banned, as James Madison wrote in the Federalist Papers.
It ought to be considered as a great point gained in favor of humanity that a period of 20 years may terminate forever within these states, a traffic which has so long and so loudly upbraided the barbarism of modern policy, that within that period it will receive a considerable discouragement from the federal government, and may be totally abolished by a concurrence of the few states which continue the unnatural traffic in the prohibitory example which has been given by so great a majority of the Union. Happy would it be for the unfortunate Africans if an equal prospect lay before them of being redeemed from the oppressions of their European brethren."
Madison got his wish. In 1808, Congress banned the slave trade, but domestic slavery lived on in America for another half-century, and another major provision in the Constitution buttressed the institution.
Article 4, Section 2. No person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due.
This passage, known as the Fugitive Slave Clause, demanded the return of escaped slaves to their owners. More than any other part of the Constitution, this clause provoked the wrath of anti-slavery abolitionists during the mid-19th century. Why? Because according to the Fugitive Slave Clause, even free states were required to participate in the enforcement of slavery by returning runaway slaves. Henry David Thoreau protested the Fugitive Slave Clause in his famous essay on civil disobedience. The famous abolitionist William Lloyd Garrison had this clause foremost in mind when he assailed the Constitution as a covenant with death and an agreement with hell. If we wish to appreciate the historical importance of the Fugitive Slave Clause, we need only remember the infamous case of Dred Scott, decided by the Supreme Court in 1857. In this decision, Chief Justice Taney declared,
"There are two clauses in the Constitution which point directly and specifically to the Negro race as a separate class of persons, and show clearly that they were not regarded as a portion of the people or citizens of the government then formed."
Chief Justice Taney cited the Slave Trade Clause and the Fugitive Slave Clause. With these as his constitutional pillars, Taney supported one of the most despised conclusions in the history of the Supreme Court. Black Americans, he declared, were not entitled to the protection afforded to citizens of the United States.
These two provisions show conclusively that neither the description of persons therein referred to, nor their descendants were embraced in any of the other provisions of the Constitution. For certainly these two clauses were not intended to confer on them or their posterity the blessings of liberty, or any of the personal rights so carefully provided for the citizen.
Article 1, Section 8 is one of the most important parts of the Constitution. In this section we find the powers specifically granted to Congress, enumerated powers as they are often called.
Article 1, Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States. To regulate commerce with foreign nations, and among the several states, and with the Indian tribes. To establish an uniform rule of naturalization, and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States. To establish post offices and post roads. To promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. To constitute tribunals inferior to the Supreme Court. To define and punish piracies and felonies committed on the high seas, and offenses against the law of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. To raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. To provide and maintain a navy. To make rules for the government and regulation of the land and naval forces. To provide for calling forth the militia, to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may by cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof.
These enumerated powers, as we shall see, are among the most important and controversial parts of the Constitution. How did they find their way into the Constitution? Well, the original Virginia plan, on which much of the Constitution was based, did not include an enumeration of powers. Rather, it specified that Congress should, in its words, legislate in all cases to which the separate states are incompetent. This provision was accused of vesting Congress with indefinite powers. Edmund Randolph, who had introduced the Virginia plan, denied the intention. Then James Madison, who had authored much of the Virginia plan, stated his views on the enumeration of powers.
I brought with me into this convention a strong bias in favor of an enumeration of and definition of the powers necessary to be exercised by the national legislature. But I also brought doubts concerning its practicability. My wishes remain unaltered, but my doubts have become stronger. What my opinion might ultimately be, I cannot yet tell. But I should shrink from nothing which should be found essential to such a form of government as would provide for the safety, liberty, and happiness of the community. This being the end of all our deliberations, all the necessary means for attaining it must, however reluctantly, be submitted to.
Madison shared the concern of many delegates who favored a strong central government. An enumeration of congressional powers, these nationalists feared, might eventually tie the hands of the central government. Nationalists had vigorously criticized the Articles of Confederation as too weak and inflexible to deal with America's problems, and the Articles granted to Congress only those powers expressly delegated to it by the states. Nationalists wanted to avoid the same mistake in the Constitution. 6 weeks after Madison's comment, the problem of enumerated powers surfaced again. South Carolina's Pierce Butler voiced his concern over the proposed power of Congress to legislate where individual states are incompetent.
I call for some explanation on the extent of this power, particularly of the word incompetent. The vagueness of the terms renders it impossible for any precise judgment to be formed.
Nathaniel Gorham from Massachusetts responded,
The vagueness of the terms constitutes the propriety of them. We are now establishing general principles to be extended hereafter in details, which will be precise and explicit.
The convention, Gorham believed, would eventually hammer out a list of specific congressional powers. He was right. On July 26th, after 5 weeks of debates and compromises, the convention adjourned to allow a 5-man committee of detail to draft a preliminary version of the Constitution. 10 days later, the committee submitted its draft. It enumerated 18 powers of Congress, and these were similar to the 18 powers which eventually were included in the final Constitution. How did the Committee of Detail arrive at its list of powers? The answer to this question involves one of the most controversial and maligned delegates to the Federal Convention, South Carolina's Charles Pinckney. On the 3rd day of the convention, after Edmund Randolph had submitted the Virginia Plan, Charles Pinckney submitted his own plan for a constitution. Unlike the Virginia Plan, Pinckney's plan contained a list of enumerated powers. This plan was ignored by the convention, but the Committee of Detail apparently drew from it when formulating its list of enumerated powers. Here we enter murky water, because the exact content of Pinckney's draft is something of a mystery. The original copy did not survive, so many years after the convention, as the official records were being readied for publication, Pinckney was asked to supply a copy of his plan. Pinckney happily complied, and the document he sent bears a striking resemblance to the finished Constitution. Indeed, it made Pinckney look like a major architect of the Constitution. After the Pinckney plan was printed, Madison was outraged. Pinckney, Madison suggested, had doctored his plan after the fact so as to conform with many features of the final Constitution. In 1830, Madison said he was going to write to Pinckney, asking and even requiring an explanation. Unbeknownst to Madison, however, Pinckney had died years before, so the mystery of Charles Pinckney remained unsolved. Was Charles Pinckney an unsung father of the Constitution? Modern historians are divided on this controversy. Madison's distinguished biographer, Irving Brandt, calls Pinckney a sponger and a plagiarist. Other historians have come to Pinckney's defense, however. According to one account of the Constitutional Convention, Pinckney was cheated of credit for his role in modeling the Constitution by James Madison and his supporters. Pinckney's defenders have credited him with originating between 21 and 43 provisions of the final Constitution. Pinckney agreed that he had been robbed of credit as an architect of the Constitution. His insistent claims led his colleagues to saddle him with the sarcastic nickname of Constitution Charlie. Well, did Constitution Charlie originate the enumeration of congressional powers found in the Constitution? Most likely, yes. From Madison's own convention record, We know that Pinckney objected to the vague wording of the Virginia Plan, which gave Congress power to legislate in all cases to which the state legislatures are individually incompetent. Early in the convention on May 31st, Pinckney said,
I object to the vagueness of the term incompetent. I cannot well decide how to vote until I see an exact enumeration of the powers comprehended by this definition.
Article 1, Section 8 of the Constitution contains 18 clauses which enumerate the powers of Congress. Among these powers, the first and last have proved the most important and controversial. Therefore, we shall focus on these two clauses. The first clause of Article 1, Section 8 reads, in part,
The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States.
This is one of the most important sentences in the Constitution. It vests a taxing power in Congress, a power it was denied under the Articles of Confederation, and it contains the famous General Welfare Clause, which has been subjected to a variety of interpretations. Basically, this sentence can be, and has been, interpreted in one of two ways, depending on the emphasis given to an all-important comma. This comma appears after the words, The Congress shall have power to lay and collect taxes, duties, imposts, and excises. A comma is inserted at this point, after which the sentence continues, to pay the debts and provide for the common defense and general welfare of the United States. Here is the basic controversy. Is Congress empowered to levy taxes for the purpose of providing for the general welfare of the United States? Or is Congress empowered to levy taxes and then empowered to provide for the general welfare of the United States as a separate and distinct power? This may seem to be an exercise in semantics, but it is of great importance. If the General Welfare Clause is not tied to taxation, if Congress is authorized to provide for the general welfare as a separate and distinct power, then Congress is given enormous power when implementing what it considers necessary for the general welfare. The wording of this clause is ambiguous. Fortunately, however, framers of the Constitution were clear about its intended meaning. In the Federalist Papers, for example, James Madison argued for a restricted interpretation. The words common defense and general welfare, he pointed out, had been taken from the Articles of Confederation. In that document, these words had not been used to confer a general power on Congress to promote the general welfare. In the same way, according to Madison, when framers of the Constitution included the words common defense and general welfare in the Constitution, they had no intention of conferring an indefinite power on Congress to promote the general welfare.
For what purpose could the enumeration of particular powers be inserted, if these and all others were meant to be included in the preceding general power? What would have been thought of the convention delegates if, attaching themselves to these general expressions and disregarding the specifications which ascertain and limit their import, they had exercised an unlimited power of providing for the common defense and general welfare?
Article 1, Section 8, according to Madison, empowers Congress to levy taxes for the purpose of providing for the common defense and general welfare of the United States. Article 1, Section 8 does not give Congress a general mandate to promote the general welfare. Well, Madison had a strong case. We can see this by tracing the evolution of the General Welfare Clause during the Constitutional Convention. On August 6th, the Committee of Detail reported its rough draft of the Constitution. This draft never used the words common defense and general welfare. It stated simply, the legislature of the United States shall have the power to lay and collect taxes, duties, imposts, and excises. 12 days later, on August 18th, the convention debated whether Congress should be empowered to pay off not only its own war debts, but the war debts of individual states as well. South Carolina's John Rutledge suggested forming a committee to consider this question. His motion included the words, common defense.
I move that a grand committee be appointed to consider the necessity and expediency of the United States assuming all the state debts. A regular settlement between the Union and the several states will never take place. The assumption would be just, as the state debts were contracted in the common defense.
A committee was formed to consider the problem of state debts, known as the Committee of 11. Its report was presented on August 21st by New Jersey's William Livingston. Here, for the first time during the convention, the words common defense and general welfare made their appearance.
The legislature of the United States shall have power to fulfill the engagements which have been entered into by Congress, and to discharge as well the debts of the United States as the debts incurred by several states during the late war for the common defense and general welfare.
Ultimately, the convention voted against this provision. It did not empower Congress to pay off state debts accumulated during the war. The convention returned to the original wording of the Committee of Detail, where the words common defense and general welfare were not used. On August 25th, however, as delegates were discussing how to pay off the public debt, Connecticut's Roger Sherman moved to reinsert the words common defense and general welfare.
I think it necessary to connect with the clause for laying taxes, duties, etc., an express provision for the object of old debts. I move to add to the power to lay and collect taxes, duties, imposts, and excises the words, for the payment of said debts, and for the defraying the expenses that shall be incurred for the common defense and general welfare.
Sherman's extra words were objected to as unnecessary, and his motion failed to pass. Days later, however, after more debate on the public debt, the Committee of 11 wrote another report. Presented by New Jersey's David Brearley, this report reinserted the words common defense and general welfare.
The legislature shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States.
This version is virtually identical to the clause eventually included in the Constitution. Significantly, small state men like Roger Sherman and David Brearley were behind the effort to include the words common defense and general welfare. These words, in their view, restricted the taxing power of Congress, as Roger Sherman said in a letter written shortly after the convention.
The objects for which Congress may apply monies are the same mentioned in the 8th Article of the Confederation. That is to say, for the common defense and general welfare.
Nationalists were not entirely happy with this restriction on congressional taxing power, but Pennsylvania's Gouverneur Morris, a fervent nationalist, made a last-ditch effort to turn a minor defeat into a major victory. Morris wrote the final draft of the Constitution, and in so doing he took some liberties. After the words to lay and collect taxes, duties, imposts, and excises, Morris inserted a semicolon instead of a comma. As the historian Forrest McDonald has noted, that would have transformed the subsequent words to pay the debts and provide for the common defense and general welfare of the United States into a positive and broad grant of power. Roger Sherman detected this little trick by Morris, and the original comma was restored. Thus, the general welfare clause again became what it was intended to be, a restriction on the powers of Congress. If Article 1, Section 8 restricts the powers of Congress, critics of the Constitution did not believe it restricted them enough. This section begins,
The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States.
This section, critics charged, grants to Congress unlimited powers to tax. Congress can tax without restraint. Luther Martin, a Maryland delegate to the Philadelphia Convention, was outraged.
By the power to lay and collect imposts, Congress may impose duties on any or every article of commerce imported into these states, to what amount they please. By the power to lay excises, a power very odious in its nature, since it authorizes officers to go into your houses, your kitchens, your cellars, and to examine into your private concerns. The Congress may impose duties on every article of use or consumption, on the food that we eat, on the liquors we drink, on the clothes that we wear, the glass which enlighten our houses, or the hearths necessary for our warmth and comfort. By the power to lay and collect taxes, they may proceed to direct taxation on every individual, either by a capitation tax on their heads or an assessment on their property. By this part of the section, therefore, the government has a power to tax to what amount they choose, and thus to sluice them at every vein, as long as they have a drop of blood, without any control, limitation, or restraint.
Melancton Smith, the leading opponent of the Constitution in New York, believed governmental powers should be clearly defined.
It is necessary that the powers vested in government should be precisely defined, that the people may be able to know whether it moves in the circle of the Constitution.
Article 1, Section 8 is intolerably vague, Smith continued, so the federal government will push its taxing power to the limit.
It is a general maxim that all governments find a use for as much money as they can raise. Indeed, they have commonly demands for more. Hence it is that all, as far as we are acquainted, are in debt. I take this to be a settled truth, that they will all spend as much as their revenue, that is, will live at least up to their income. Congress will ever exercise their powers to levy as much money as the people can pay.
Article 1, Section 8 says Congress can tax, but it does not say how much Congress can tax. This, according to critics of the Constitution, is like giving Congress a blank check. Alexander Hamilton responded to this objection in the Federalist Papers. Hamilton stressed the importance of revenue to a government.
A nation cannot long exist without revenue. Destitute of this essential support, it must resign its independence and sink into the degraded condition of a province. This is an extremity to which no government will of choice accede. Revenue, therefore, must be had at all events.
Money, Hamilton maintained, is the very lifeblood of government.
Money is, with propriety, considered as the vital principle of the body politic, as that which sustains its life and motion and enables it to perform its most essential functions. A complete power, therefore, to procure a regular and adequate supply of revenue, as far as the resources of the community will permit, may be regarded as an indispensable ingredient in every constitution.
For Hamilton, the case was clear. If the national government is charged with certain responsibilities, then logically it must have the right to use whatever means are necessary to discharge those responsibilities.
Whether there ought to be a federal government entrusted with the care of the common defense is a question in the first instance open to discussion. But the moment it is decided in the affirmative, it will follow that that government ought to be clothed with all the powers requisite to complete execution of its trust.
No constitutional limit should be placed on taxes, Hamilton argued, because we cannot predict the future.
These powers ought to exist without limitation, because it is impossible to foresee or to define the extent and variety of national exigencies, and the correspondent extent and variety of the means which may be necessary to satisfy them.
The Constitution empowers the Congress to provide for the common defense. An unlimited power to tax is necessary to achieve this goal.
The circumstances that endanger the safety of nations are infinite, and for this reason no constitutional shackles can wisely be imposed on the power to which the care of it is committed. This power ought to be coextensive with all possible combinations of such circumstances, and ought to be under the direction of the same councils which are appointed to preside over the common defense.
Hamilton made this point repeatedly in the Federalist Papers.
As the duties of superintending the national defense and of securing the public peace against foreign or domestic violence involve a provision for casualties and dangers to which no possible limits can be assigned, the power of making that provision ought to know no other bounds than the exigencies of the nation and the resources of the community.
James Madison agreed with Hamilton's reasoning. National defense is a primary responsibility of the central government.
Security against foreign danger is one of the primitive objects of civil society. It is an avowed and essential object of the American Union. The powers requisite for attaining it must be effectually confided to the federal councils.
In addition to taxation, Article 1, Section 8 enumerates other powers necessary to national defense, including the power to raise and support armies. All such powers, Madison contended, ought to be unlimited, because a nation cannot foresee or control future threats to its security.
With what color of propriety could the force necessary for defense be limited by those who cannot limit the force of offense? If a federal constitution could chain the ambition or set bounds to the exertions of all other nations, then indeed might it prudently chain the discretion of its own government and set bounds to the exertions for its own safety. How could a readiness for war in time of peace be safely prohibited unless we could prohibit in like manner the preparations and establishments of every hostile nation?
Thus, in the Federalist Papers, both Hamilton and Madison argued vigorously against restricting the congressional powers enumerated in Article 1, Section 8, especially the power to tax. Enumerated powers specify the purposes for which Congress can tax, but within these boundaries there should be no limits on the amount Congress can tax. Hamilton summarized the basic principle involved.
A government ought to contain in itself every power requisite to the full accomplishment of the objects committed to its care, and to the complete execution of the trusts for which it is responsible, free from every other control but a regard to the public good and to the sense of the people.
The struggle to ratify the Constitution of the United States was lively and bitter. Opponents of ratification often criticized the immense powers which the Constitution gives to the central government. Many parts of the Constitution were attacked, but none was castigated with more vehemence than the final clause in Article 1, Section 8.
The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof.
This famous necessary and proper clause is often called the elastic clause. Why? Because through centuries of judicial interpretation, this clause has been used to expand the powers of Congress. It enables Congress to make all laws which are necessary and proper to discharge its constitutional duties. In so doing, this clause has opened to Congress a vast arena of discretionary powers, that is, powers not expressly granted by the Constitution. During the ratification struggle, Hamilton observed, the necessary and proper clause was a center of controversy.
This clause has been the source of much virulent invective and petulant declamation against the proposed Constitution. It has been held up to the people in all the exaggerated colors of misrepresentation as the pernicious engine by which their local governments were to be destroyed and their liberties exterminated, as the hideous monster whose devouring jaws would spare neither sex nor age, nor high nor low, nor sacred nor profane.
Hamilton's remarks were something of a caricature. Many Americans were legitimately concerned that the necessary and proper clause would be used to justify the continuous expansion of the federal government. One critic of the Constitution expressed this concern emphatically.
Under such a clause as this, can anything be said to be reserved and kept back from Congress? Can it be said that the Congress have no power but what is expressed? To make all laws which shall be necessary and proper is, in other words, to make all such laws which the Congress shall think necessary and proper. For who shall judge for the legislature what is necessary and proper? Who shall set themselves above the sovereign? What inferior legislator shall set itself above the supreme legislature? What limits are there to their authority? I fear none at all. For surely it cannot justly be said that they have no power but what is expressly given to them, where by the very terms of their creation they are vested with the powers of making laws in all cases necessary and proper, when from the nature of their power they must necessarily be the judges what laws are necessary and proper.
In the Federalist Papers, Madison and Hamilton defended the necessary and proper clause. In their eyes, the need for this clause was virtually self-evident. As Madison wrote,
"Few parts of the Constitution have been assailed with more intemperance than this. Yet on a fair investigation of it, no part can appear more completely invulnerable. Without the substance of this power, the whole Constitution would be a dead letter. Those who object to the article, therefore, as a part of the Constitution, can only mean that the form of the provision is improper. But have they considered whether a better form could have been substituted?"
According to Hamilton, if a government has certain duties, then logically it must possess the means to discharge those duties.
What is a power but the ability or faculty of doing a thing? What is the ability to do a thing but the power of employing the means necessary to its execution? What is a legislative power but a power of making laws? What are the means to execute a legislative power but laws? What is the power of laying and collecting taxes but a legislative power, or a power of making laws to lay and collect taxes? What are the proper means of executing such a power but necessary and proper laws?
It is nonsense, Hamilton argued, to tell a government to do something and then to tie the government's hands. It is a self-evident truth that a Congress charged with certain responsibilities also must be charged with the means necessary and proper to meet those responsibilities.
This clause authorizes the national legislature to pass all necessary and proper laws. If there be anything exceptionable, it must be sought for in the specific powers upon which this general declaration is predicated. The declaration itself, though it may be chargeable with tautology or redundancy, is at least perfectly harmless.
If the necessary and proper clause is self-evident and harmless, then why was it put in the Constitution in the first place?
The convention probably foresaw that the danger which most threatens our political welfare is that the state governments will finally sap the foundations of the Union, and might therefore think it necessary, in so cardinal a point, to leave nothing to construction.
Next, Hamilton responded to a criticism commonly hurled at the necessary and proper clause.
It may be asked, who is to judge of the necessity and propriety of the laws to be passed for executing the powers of the Union? I answer that the national government, like every other, must judge in the first instance of the proper exercise of its powers, and its constituents in the last. If the federal government should overpass the just bounds of its authority and make a tyrannical use of its powers, the people, whose creature it is, must appeal to the standard they have formed, and take such measures to redress the injury done to the Constitution as the exigency may suggest and prudence justify.
According to Hamilton, if a government is to function effectively, it must possess not only those powers expressly delegated to it, but implied powers as well. In order to implement its laws, a government must have discretionary powers at its disposal. Many opponents of the Constitution disagreed. They believed a government should have only those powers expressly delegated to it by the people. Mercy Warren explained how this controversy over expressed powers led some Americans to oppose the Constitution.
These objections were not the result of ignorance. They were made by men of the first abilities in every state, men who were sensible of the necessity of strong and energetic institutions, and a strict subordination and obedience to law. These judicious men were solicitous that everything should be clearly defined. They were jealous of each ambiguity in law or government, or the smallest circumstance that might have a tendency to curtail the republican system or render ineffectual the sacrifices they had made for the security of civil and religious liberty to themselves. They also wished for the transmission of the enjoyment of the equal rights of man to their latest posterity. They were of opinion that every article that admitted of doubtful construction should be amended before it became the supreme law of the land. They were now apprehensive of being precipitated, without due consideration, into the adoption of a system that might bind them and their posterity in the chains of despotism.
Compare this position to that of James Madison, who warned what will happen if the Constitution restricts Congress to expressed powers.
The new Congress would be continually exposed, as their predecessors have been, to the alternative of construing the term expressly with so much rigor as to disarm the government of all real authority whatever, or with so much latitude as to destroy altogether the force of the restriction.
The problem of expressed powers was a sensitive issue for critics of the Constitution. They feared the government, in exercising its necessary and proper discretionary powers, might trample on individual rights. Therefore, many Americans wished to restrict the power of government by including a Bill of Rights in the Constitution. They got their wish 3 years after the Constitution had been ratified. In 1791, the first 10 amendments to the Constitution, the Bill of Rights, expressly limited the powers of the American government.
If you enjoyed this discussion, you will probably enjoy other products of the Cato Institute, including tapes of policy forums, monographs, books, and publications. For more information on the Cato Institute, write to Cato Institute, 1000 Massachusetts Avenue Northwest, Washington, D.C., 20001, or call 202-842-0200. For a catalog of Cato publications, call toll-free 1-800-767-1241, or visit our site on the World Wide Web at http://www.cato.org. We hope that you have enjoyed this presentation of the Cato University, a project of the Cato Institute.